Sharpie in here. I do have a knob here to turn, but I don't have any faith in it having any effect. But I've at least turned it. You'll be glad to know.
Thank you. So we had finished by just looking at the letter of claim and what was requested. Interestingly, you will see that in response, one of the things that's been said is that what we are seeking by way of disclosure from Titan are confidential documents. So although they say against us, well, all of this information was not confidential, when we request information from them, they say it's confidential. And you will find that in the last sentence of paragraph 47 for this appeal. It's page 32 of the core bundle. And you will see there that's what said, Titan pointed out the same problems in the letter before action and declined to open up its confidential documents for inspection, particularly in the context of such broad requests. Now, I have shown you the very limited requests that were made in that pre-action correspondence. The response that we got back and is reiterated to the court here is that that information is confidential. And so we say that reinforces what I have been submitting about the confidentiality of this document, of these documents, something both parties to these proceedings fully understand. Of course, the test that you're looking at for an amendment is whether the party can understand the case that it has to meet. So can I just then go forward to the response, or just to show you, to complete the chronology, and then I'll come on to the pleading, because I'm trying to take these documents in the order in which they came chronologically. So page 12 of the supplemental bundle is Quinn Emanuel's letter of response, and you'll see in particular 20 and 21 at page 15, those paragraphs are an outright refusal to provide us with anything, including the limited request that we've set out. In the skeleton, it said that request was based on the fact that those documents were confidential. Then, if we go to page 17, we see there was a further letter sent on the 21st of May. So we had another go, and we set out at page 19 some of the deficiencies in the letter of response. 12.1, we pointed out that at the very least, Titan should have confirmed whether or not it denies utilising any of Tavistock's confidential information in the creation of the MPS, and in particular the building of its active and passive models. Now, to date, there's not been a single witness from Titan who has actually denied this. So you'll see from the judge's judgment that one of his criticisms was that it was Mr. Gailani, and only Mr. Gailani, who put in evidence to support the summary judgment application, all of the applications that were made, whereas by contrast, we had statements from solicitors, but we did also serve a statement from Mr. Raven. There is no equivalent evidence before the court from Titan, and that's important.
So when you say no witness has denied,
yes,
do you mean no Titan person, or no witness even on information and belief?
I don't want to say something that's inaccurate, so I would need to check precisely what Mr. Gailani says, and maybe that he says that on information and belief, but you will see that we put in evidence to the court to explain why we didn't accept that and why we believed confidential information had been used. We didn't have a response from anyone on the investment team. So you don't have David Chandler, you don't have any of the people you see on the emails saying we built.
No, I understand that, and that's one point, but a different point, and I wasn't sure if you were making it or
Yes,
not,
I understand.
is that nobody on the Titan side has denied this.
I will check and let you know before
Okay.
I give you. I don't want to give you an inaccurate
Thank you.
answer. And then at 12.2, letter of response failed to address the question of whether any confidential information was utilised in the drafting of the Titan Active fact sheet. 12.3 also fails to address the significance of the emails sent by David Chandler. These emails demonstrate that Titan, utilising its knowledge of funds which were held by the Tavistock MPS, acquired for the benefit of Titan MPS. And then in paragraph 15, you will see that we then tried to give some further information about the confidential information. So we set out 3 categories. 15.1, knowledge of Tavistock's proposed investment strategies, including details as to the individual assets which were to be available via the MPS. And just to reiterate, we do not accept what's submitted to you, and we say this will be a matter of trial, but we say that the recommendations that were made to Tavistock, this was an iterative process. Recommendations would be made, Tavistock would look at them, they might input, there might be a discussion, and then it would be moved forward. But Tavistock was paying for those recommendations to be made. And we say that those recommendations are confidential information which would be valuable in the hands of a competitor. Because normally you would not be privy to that sort of information. They were not, on our case, things that Titan could take and use for their own benefit.
Well, again, when we get there, if you're saying that recommendations by Titan to Tavistock are Tavistock's
Yes.
confidential information, you'll need to show us where you plead that.
I will. When this assertion was made by Titan, you will see in the reply, it's the passage that Lord Justice Miles has already flagged up. I think it's 336, but I'll take you to it. We say in terms, it doesn't matter that it was Titan making the recommendations. I also remind the court that we have 2...
Sorry, does that mean your answer is going to be that it's not pleaded in the amendment pleading we'd be looking at, but in a later pleading?
Well, it's in the reply. When we use Tavistock, we understand that to cover anything that Tavistock was paying for, because we didn't see the product that Titan was producing as Titan's product. So we'll go through the pleadings, but in some ways, my clients always regarded this as their product. They were paying for it, and Titan was being remunerated for it. So to that extent, Titan is acting as our agent in producing those recommendations.
Doesn't the agreement say they're not an agent?
Well, but it says they're not allowed to use that information.
Well, for their own purposes.
For their own purposes.
But that all goes back then to what the information is. I mean, and you certainly haven't pleaded, I think, that they were acting as your agent in the sense that, I don't know quite how it would work, but it'd be something like, because they were your agent, you were then disclosing the information to them?
Sorry, the use of the word agent may be loose language. I'm trying to convey that we were paying them to produce this information. We were paying them they were getting half of the fee that came from the Tavistock MPS. And we will go to the Outsourcing Management Agreement later. We say under the terms of the Outsourcing Management Agreement, when you look at 5.1, it applies to any information, whether coming from or going to another party. Secondly, even if we were wrong on that, we have an equitable duty of confidence. And we say that would cover this, because it's quite clear when you read the agreement as a whole that what Titan are doing is effectively fulfilling the role that we would have done ourselves, but of course those people have transferred into Titan's employment. But we were certainly not agreeing to pay them and then to allow them to use that information for them to create a parallel MPS. So we say that that is also covered by the pleading, which we'll come on to. But if we can just look at 15.1, finish this off. 15.2 is the due diligence in respect of individual assets which were to be available via the MPS, including risk and stability, information relating to the timing of the individual investments, and then the fact sheets themselves. And then if I could also just ask you to look at 21, paragraph 21, page 21. This appeal was open to you on the basis that Titan had never used any of this information and it wasn't public and there wasn't a product. I don't expect the court to obviously resolve this issue, but it shouldn't have been put in the way it was, because this is a very, very hotly contested issue. And you will see that what happened, if we look, I'm not going to go through all the details, but you will see that 21.1, the letter of claim, was accompanied by a copy of the Titan 8 Activate fact sheet. The document is dated the 31st of March 2024, which is inconsistent with the statement in the letter of response that the Titan active and passive model only existed until August 2023. Last sentence. TAM notes that it appears the fact sheets have been removed from Titan's website since the date of the letter of claim. And then 21.2 notes that since the letter of claim, there have been changes to the Titan website. Halfway through, the website page is no longer accessible, but we had kept a copy of it, which said, in addition to our off-the-shelf range, we offer a bespoke MPS service designed to our client's specific risk profile and investment mandate requirements. Then 21.3 over the page. Other changes have been made to the Titan website. And then 21.4, quotes from articles available in the press on the 14th of March 2023 announcing Titan's MPS and noting that those were all managed by John Leaper and his investment team. So the very people who had transferred over from Tavistock. And again, when we talk about inference, it hasn't, for example, been said to us, well, you've got this all wrong. The Titan MPS was developed by a separate group of people. Those who worked on, who were part of the investment team, had nothing to do with it, were perfectly entitled to create this, which of course Titan would have been entitled to do that, to employ other people who weren't involved with it. Instead, they used the very same people who were working for Tavistock MPS and who had access to all of this information that would not have been in the public domain and which they were being paid for. So can I then look at the pleading, which is the next document in time. And if we can start at the beginning, perhaps controversially, it's page 181. And if we go to 182 and paragraph 5, and again, I refer to this because this is part of the bigger picture. It's part of our inferential case that from an early stage, Titan Wealth undermined the basis of the SPA, and that's when we talk about the purchase of LABC using our confidential information. And then you will see halfway down, further, Titan AM also abused its privileged position under the OMA and the privileged relationship between the Titan and Tavistock groups more generally by secretly misusing Tavistock PLC's confidential information and trade secrets. and copying so as to build and operate its own MPS directly derived from Tavistock's MPS without the knowledge or license of Tavistock. Now, the copying of those fact sheets, as I said, is going to trial. The disclosure that we requested in the pre-action disclosure has been agreed to be part of the copying allegations. So the very disclosure that we were refused will, in due course, be given to us as part of the allegations that are going to trial. Which
does that include both? Because there were two elements to that. One was the fact sheets.
Yeah.
The other was what was called the investment history.
Yeah.
Has that been agreed also?
I will check. No. I'll double check. You're correct to pick me up on that. The fact sheets will be disclosed. The investment strategies we've seen is said to be confidential.
It's called the investment histories, I think.
Yes. But that's said to be confidential, paragraph 47. And yet, when we talk about our investment strategy, it's said that's not confidential. And then if we can go forward to page 189, paragraph 35.2. We've set out there a history of Tavistock Wealth Limited. Obviously, that had the advisory business, such as Tavistock Partners, and then 35.2, the investment management business, which is split into the Acumen funds and then the MPS, the Tavistock MPS. And you are aware, obviously, that the original proposal was that both would be purchased. In the end, only the Acumen funds was purchased. And then at 40.A, so page 191, this is where we have the definition of what the Tavistock MPS is. And when we come on to look at the MPS counterclaim, you will see that we refer back to this definition. So that is a series of different investment strategies and risk levels. This was, as I explained earlier, something that had been built up since 2014, and the recommendations that were being made were feeding into the existing product. And again, repeating there that significant time, expertise and resources in identifying and selecting appropriate asset classes and product types from a wide range would be put into that. And we would say that all of that is a commercial product that contains confidential information. And that's why when we come to look at confidential information, the definition of that, it includes all of this, save for information that's available publicly.
That's a description of a business, if you like.
Yes.
You can't really have a claim just saying the whole of our business is confidential information, can you?
Well, the whole of the business, how the Tavistock MPS was put together is confidential. So what's publicly available is obviously not, but the way in which that business, the way in which the MPS had been built, researched and put together obviously is, and we'll see that through Ben Raven's statement. He explains in a bit more detail, because a competitor normally would not have any access to anything other than what was publicly available. And again, I do reiterate that what we requested in the letter of claim is said by Titan itself to be confidential. So the strategies are confidential. And that's the strategies, the way in which that business is built and operated, save to the extent it's publicly available information, is confidential information. And if we look at 41, we can see a bit more detail given. For each MP offered by Tavistock, the portfolio is a basket of investments selected and managed by Tavistock AM. Obviously, the selection was then done in conjunction with Titan after the relevant date, in line with the strategy and within a risk or volatility range which is set out in a publicly available fact sheet. And then if you go to 41.3, you will see there that Tavistock AM designates the MP with an internal risk rating classification and manages the portfolio with a view to maintaining that classification. And the risk rating from 1 to 10. And again, you will see that in the letter of claim, we made this very point that the Titan MPS was the same as, or substantially similar to, the Tavistock MPS in this regard. But they wouldn't have access to internal risk ratings or internal management decisions without having been party to the OMA.
Are these risk ratings common across the industry so that everyone knows what you mean by a risk rating of 3, or would a Tavistock risk rating of 3 mean something different from another company's risk rating of 3?
I'll just check. Yeah. I thought that was the answer. So the footnote in the letter of claim that I took you to explains that they may be different. If we go back to the supplementary bundle, page 6. So Titan MPS used 3 to 8, which is identical to Tavistock MPS, although the market range of risk profiles is 1 to 10.
I understand that.
Yeah.
But how do we know that a Tavistock risk rating of 3 means the same as a Titan risk rating of 3, or are these numbers which are understood in the same way across the industry?
I will check. I'm not sure we know the answer to that, but
I mean, I'd rather understood that these were market standard figures, so that if you say this has got a risk rating of 3, everybody knows exactly what you mean by that. Because if it's an internal risk rating, which is confidential, it's pretty useless because you're not telling anybody what you mean when you say this is a risk rating of 3.
well, I mean, as I say, this isn't a point that's been taken against us or taken issue with in the evidence, and I don't want to speak. This is one of the dangers. We're at the stage of an amendment application. Certainly, we have said there is an internal risk rating classification. Precisely what that is or how it correlates to what's published in the fact sheet. Standing here on my feet, I'm not sure I'm able to tell you that accurately. And in fairness, we can certainly look at Ben Raven's statement to see if he deals with it. But there is internal risk ratings that are there, and that's something we've always pleaded and has never been suggested that these don't exist.
I had assumed, perhaps incorrectly, that there were understood ratings, and that is how one gets to one's 3 to 8. Yeah. But this is only in my head. I have no basis for it. But what you have just said is that there is something different, which is actually the way in which these various investments are looked at internally, and that might be different from the overall rating as it comes out on a fact sheet.
Yes. Well, can I put it in this way? Footnote 1 of the letter of claim shows that different companies use different numbers. And so Titan had access to the numbers that we were actually using in real time, and they had a complete picture of the numbers that we were actually using. The details of what the numbers mean can partially be seen in fact sheets, but as we know, they can't fully be seen, which is why when we were asked to give more particulars of what had happened, what of our confidential information Titan had used, we made the request for the information that we did, which was to say we can't actually, this is what we can tell from one fact sheet, but we need all the fact sheets, and then we would need all of that investment information, the strategies, etc., that sit behind the fact sheets. So,
well, but both yours and their fact sheets refer to the internal risk rating,
yes,
which suggests that that's not something different from the public risk rating. But whether that's something which everybody would understand, or whether you'd need to know the company's internal way of rating it, I don't know.
Well, there's no doubt if you're privy to internal discussions, you're going to have additional confidential information that is not in the fact sheets. It's not suggested by Titan that there's no confidential information in what's produced because everything's publicly available and everything's in the fact sheets. In fact, the opposite is their position, because when we asked for their details of their strategies, they said it's confidential. So
if they're entirely internal, then how do you know they're using the same ones as you?
Because what we can tell from the fact sheets creates an inference that they are, and that's
They may
why
be
we
different.
set out. Well, they might be, but they won't tell us. What we did in the letter of claim was to take all the publicly available information that we could, and you'll remember those 4 categories, to set out why we said on the face of it, it looked as if they were copying. Now, if they haven't copied, it's very simple for them to just give us this information and explain that they haven't. And then, so those are the definitions. And then, if we go forward, please, to the pleading out, we then go forward to page 228. Paragraph 120, we have Titan Wealth choosing not to purchase the Tavistock MPS, the repetition of paragraph 36. And then 121, we have some further provisions of the SPA, as well as those in paragraph 52 above. And then 121A, we have the reference to and the reliance on the terms of the OMA. And again, I go back to these terms to show how wide they are. We've pleaded them out here. Confidential information is all information disclosed by either party to the other party in connection with this agreement, which is labelled as confidential, which should reasonably be considered as confidential because of either its nature or the manner of its disclosure. And that will cover the strategies being produced for us by Titan. Because what is being protected is all information. It doesn't matter who it's disclosed by. Of course, all of the information that Titan was producing was being used by Tavistock for the Tavistock MPS. But that is the definition of confidential information, and Titan themselves consider this sort of information about internal strategies, recommendations, to be confidential.
Well, you've made that point about 10 times now.
Yeah, sorry.
What is Titan's confidential information under this scheme? What confidential information do they have if everything they're doing for you?
Well, I don't think they're disclosing information to us that would be confidential, because they're not disclosing any information to us.
So they don't have any confidential information for the purpose of this agreement?
Well, I don't know. Say that they made a recommendation that included some of their experience, I suppose, on another MPS. I mean, that's not this case because they didn't have experience. They didn't have their own MPS. But say they had an MPS already, and they said, we'd like to, we'd recommend this as we've done in our MPS, for example.
Well, I mean, the reason I'm asking is that the next paragraph quotes clause 5.1, which appears to contemplate that both parties have confidential information. And you might think from that Titan's confidential information is what they disclose to you, and Tavistock's confidential information is what you disclose to them. That would be how such an agreement would normally work.
Yes.
If it were not for the wrinkle that, as it happens, the Titan people used to be your people.
Well, I'm not sure that's the wrinkle. The wrinkle, I would say, is that Titan don't have an existing MPS. They don't have information from their existing business that they're giving to us to input into the MPS, as it were, because otherwise it would make no sense. If it included what the recommendations they were making to us, then we wouldn't be able to use it. If that was their confidential information as opposed to our confidential information. So all of the information that Titan give us is to be used to comply with the obligations under the agreement. But of course, this agreement must be drafted like this because one can't assume that Titan won't at some point give us some confidential information. But let's just assume that that information is Titan's confidential information. That still works against Titan. Because what 5.1 says is each party shall keep the other party's confidential information confidential and shall not. And then it just says, this is very broad. It doesn't say use any confidential information belonging to the other party. It says shall not use any confidential information for any purpose other than complying with its obligations under this agreement. So even if Titan are right, and this was somehow their confidential information, the strategy, they have agreed that all of that information can only be used to comply with obligations under the OMA. And 2 then is there, couldn't disclose that to any third party. So Titan, for example, couldn't take the recommendations and give them to anyone else. So that is the foundation. And I'm not here today to prove that that's right. I'm here to show you that I have a more than fanciful prospect of proving that at trial. That's the contractual construction. And if I'm right about that contractual construction, everything that's been said to you about Titan, this being Titan's confidential information or Titan's work that they can use is wrong. Because if I'm right about that, then under this agreement, under the breadth of 5.1, Titan agreed that the only purpose for which that work, that strategy could be used was in relation to the Tavistock MPS. And I say I have a real prospect of demonstrating that at trial. Secondly, if I was wrong about that, we then have the equitable duties of confidence, which you have to look at those. Those can be wider than the contractual duties of confidence, as long as they don't conflict. It's a matter, again, for the court at trial hearing the evidence to determine this. But you will recall that the OMA has that duty of good faith. And that would be very relevant in relation to the equitable duty of confidence. There is nothing in the OMA that says in terms that Titan can use what they're paid to generate under their obligations for their own benefit. And so we say, even if we were to fail on 5.1, and we say 5.1 is very clear, Titan could and should have inserted the words use any confidential information belonging to the other party. But even then it says for any purpose other than complying with its obligations under the agreement. But secondly, there's the equitable duty of confidence. And there is nothing in this agreement that permits Titan to use whatever they do under the OMA for their own benefit. So those are the obligations that we have pleaded. These are issues of law. to be argued about at trial on issues of fact in relation to the equitable duty of confidence, all of which the trial court will look at. Then we go forward to the Titan MPS at page 243. And then the infamous paragraph 153, which was the one paragraph referred to in the grounds of appeal. It starts with the words following and pursuant to the OMA. So all of the paragraphs that I've taken to you to already are relevant and must be read into this paragraph. And then we have these words, Tavistock AM communicated information necessary to implement the Titan MPS to Titan AM. Such information form part of the MPS as described, part of the MPs as described at paragraph 41 above. I've taken you to that. Within the Tavistock MPS as described in paragraph 40A above. And so it incorporates all of those provisions.
What does that actually mean? Sorry to just ask you that question at this point, but what does it mean to say such information form part of the MPs? I mean, the MPs are the portfolios, aren't they?
They are.
And so it can't, I'm struggling a bit with the idea that the information forms part of the portfolios. What does that actually mean? It may be information about the portfolios.
Yes.
And it may be information about some aspect of the portfolios. But then one might think, you might say, well, the following aspects of the information are confidential in some way.
Well,
it can't be everything about, in other words, looking at it the other way around, it can't be the case that every bit of information about the MPs is confidential.
No, can I just make 2 points? 153E and 153F are actually introductory paragraphs to the paragraphs that follow. So these are general paragraphs describing both, they introduce both the allegations in relation to copyright infringement, starting on page 244, and then 246 is the breach of confidence allegations. So we're not specifically dealing there. It's sort of taken on a life of its own as if this is the pleading of confidential information. It's an introductory paragraph to what follows, and we go on in paragraph 153N to deal with the Tavistock, what we define as the Tavistock MPS information. So just that word, the caution about somehow reading this as our entire pleading on what's confidential. That's not the purpose of this paragraph. What it sets out is that that pursuant to the OMA, that effectively Titan is given access to the internal workings of the Tavistock MPS. That is something that Titan wouldn't otherwise have had access to. And then we have given one example there that the information included instructions as to which investments were to be onboarded for the Tavistock MPS. And then we come to the emails, which I will take you to. But this is an introductory paragraph, which is really the judge's point when we come to look at the further information, which the further information wasn't about 153E. It was about the paragraph that then later on comes later on in the pleading, which is where we actually plead out the breach of confidence. So it's not fair to say that this is the only place in which there's the pleading of the confidential information. But obviously, looking at it just through the lens of confidential information, we start getting into debates of, are those really the right words? Is it just information that Tavistock communicated to Titan? That really wasn't the point of this paragraph of the pleading. What it does do is it does define investment emails, which are then referred to later on. But it's simply setting out. So, for example, Tavistock gave Titan access to all the fact sheets and all of that, which then are copied.
But the fact sheets are public, aren't they?
Yes, but they have access to them before they're published. So that's an important distinction. Because if you look at
is that part of your
yes,
pleading?
it is part of our pleading. If you could look at 153J, as part of the Titan MPS, the Titan AM investment team created monthly fact sheets about each MP within the Titan MPS. And that copied the Tavistock fact sheet.
That's part of the copyright infringement.
That is, yes. So one is going to need to look at, as part of this claim, how what Titan MPS used and how they created those and how they went about doing that. But the point, just going back to 153E, is it's a precursor to 153F that then sets out that in or around January 2023, Titan launched its own MPS, and it was intended to be a rival to the Tavistock MPS. And then if we go forward, we get onto 153M, which is the breach of confidence. And we start with 153M, saying that they created it using confidential information and or trade secrets created or owned. Such use was unauthorised and to the detriment. Tavistock is not presently aware of all such acts of use, but will seek relief for all such uses are proven at trial. Now, the problem is we cannot go further, as Titan know, than we have done in the letter of claim in this regard as to what use was made. We simply don't know, because we don't know how they created it. We've not even been given access to the limited disclosure that we asked for in the letter of claim. And then 153N says, in light of the commercial sensitivity and value of each and all of the investment information, so that obviously is a reference there to investment information, the MPs and the Tavistock MPS, and of the context in which and purpose for which they created each part of the Tavistock MPS information was inherently confidential, save insofar as that information was deliberately published by Tavistock PLC or Tavistock AM. And we then set out at P, or O is that we took reasonable steps to keep it secret. So to the extent it was published, it obviously wasn't secret, but to the extent it wasn't, it was secret. And then 153P, the Tavistock MPS information had commercial value because it was secret.
Can I just ask you to pause at 153N for a minute?
Yeah.
What do you say is the Tavistock MPS information in a nutshell?
So the Tavistock MPS information are effectively all of the work, that's everything that sits behind, everything that's not public about the Tavistock MPS is confidential. No other competitor in the market would know the work that had been done, the analysis that had gone into that, so all of the investment strategies, all of that. It is anything that is not publicly made available, because if Tavistock was trying to create this MPS without using any of the knowledge they gained whilst being paid to carry out the OMA, they obviously wouldn't have access to any of that. And it obviously has a value. It has, we had knowledge there since 2014. We obviously were involved, as Mr. Gailani sets out, in this iterative process whereby research was done by Titan on our behalf. That was shared. It was discussed with Tavistock. Then decisions were made about what would be onboarded and what would be rebalanced. We've seen that, and we'll come on to look at Ben Raven explaining that all of that also is only made public at a certain point in time. So Titan has access to all of that information ahead of it being made public. So to the extent that information is not in the public domain about the Tavistock MPS, then it is confidential. Obviously, if we were trying to say that information that was public was confidential, that wouldn't work, because Titan could go off and do their own research to do with that. But what they can't use is take the research that we've paid for that's not available publicly and use that to then create and copy the Tavistock MPS.
So the investments that make up the portfolios?
It's the strategy, it's all of the things that are set out in the pre-action correspondence.
Well, what about... I'm just wondering about the pleading at the moment, because at the moment it seems as though all you've pleaded is the portfolio. It's the portfolios themselves, the investment information, and the Tavistock MPS, which is very broad indeed. I mean, it might be said that you're saying that everything about a company's business, which is not public, it's confidential information. And that would be a very broad way of presenting a case.
Well, but we do that in light of the OMA, my lord. So the OMA does say that any information that's created in connection with that work that's being done is to be confidential.
Well, I don't think it does say that, but that's your submission.
Well, it's certainly. I would urge you to look at that definition, and also to look at this duty of good faith. That if you look back at 19 of the supplemental bundle, there were 4 things specified: knowledge of the proposed investment strategies, including details as to the individual assets which were to be used. Titan has that ahead of time, in real time. There's due diligence in respect of individual assets, which were to be available via the MPS, including their level of risk and suitability. That's not in the public domain, or may not be until a later point in time. 3, information relating to the timing of individual investments. And 4, the fact sheets, again available in real time before they're published. So we have set out there, we've also set out the access to funds and the rebalancing that was available. So the difficulty is, it's very hard to say what confidential information was, well, it's impossible to say what they used until we know what they did and how they built it, or at least to have the limited disclosure that we asked for in the letter of claim. Because we asked for their investment strategies, and I'm not going to make the point again, but we are being told we cannot say that this information is confidential, and yet they can to withhold it from us. That can't be right. So even if you were against us on 5.1, you then have to look at this equitable duty, which would also arise. And then at 153Q, we explain why all of that MPS information was imparted to Titan AM in circumstances importing an obligation of confidence on Titan AM. So it's not just the information itself, it is the circumstances in which it is disclosed to Titan that are relevant. And that, again, I go back to the OMA, which sets out in terms that the information which should reasonably be considered confidential because of either its nature or the manner of its disclosure. And so we have pleaded out in terms at 153Q why we say this was disclosed in circumstances importing an obligation of confidence. 153Q1, we refer to the OMA itself, and then 153Q2, we say all such information was subject to an equitable duty of confidence, including because of the circumstances of the OMA and of the commercial and market context, Titan AM had implicit notice that it was confidential. And so that is how we get to where we get to at 153R, saying that Titan owed a contractual and or equitable obligation of confidence. Once we know what they actually did, once we have their confidential information, then we can give a much more precise pleading as to what it was that they misused from us, but we simply don't know what they did. So we're therefore in the position that we're in. We then, over the page at 248, because 153S is just the trade secrets pleading. No separate point is taken on that. It all hinges on whether we have given particulars of the confidential information and particulars of how that confidential information was misused. Those are the 2 points taken in this appeal. 153U is the inference which on his feet my learned friend sought to use against us. But please read those words. The precise nature and scope of use is outside the knowledge of Tavistock AM, but pending disclosure and further information and or evidence, we plead as follows. When Titan AM was discharging its obligations under the OMA to undertake the work of onboarding new investments for the Tavistock MPS, it also onboarded the same investments for Titan AM. This is demonstrated in the investment emails, and that's agreed. It's
Mr.
agreed.
Powis makes the point that that was all done openly and that your man could see that was happening.
Well, that is an issue of fact for trial. The emails are not.
Well, no, it's not. It's there on the face of the email, unless it's going to be said he was off sick for 6 months and didn't see any of them.
Well, can I just take you to the emails because they're not as clear as that. I know that's what's argued, but we don't have, and the judge didn't have, any witness statement from anyone saying, well, you knew what we were doing and you didn't say anything. But that would be an issue for trial. We have Mr. Raven saying we didn't know what was going on. We have a statement of truth saying we didn't know what was going on. Precisely what Stephen McGregor understood by these is a matter for trial in my submission. So page 296. We see there the reference to Tavistock/Titan models. Do you see that?
Yes.
Again, Tavistock understood that as referring to their models because under the OMA they understood that Titan was working for them. So they didn't understand that to mean that Titan had its own
Sorry, are you telling us now
model.
something that's in evidence or something that may be the case?
Well, this has never been a point.
So you just said how Tavistock understood it.
Well,
I'm wondering whether that's evidence based or whether that's simply a way in which they could have understood that as a matter of submission.
there's no evidence before the court. You don't have a witness statement from Stephen McGregor, for example, saying that. You equally don't have any evidence from David Chandler as to what he meant by that or how it should have been understood. But I am making a submission based on what I understand to be the position, and what has been pleaded is that this was done in secret and we didn't realise that they were building their own NPS simply by these references.
Okay.
And certainly when you look at the response, that's never formed part. So when we got the letter of response, it didn't say, well, you knew we were doing all of this, it was fine. So we haven't gone into this, my lord. This is a point that's to be taken separately. In my submission, my client should have the opportunity to address it. This is a matter for trial in my submission as to precisely what this means. Okay, there is, just to be clear, there was evidence before the judge that isn't in the bundles before you from the solicitor. It's a statement by Ms. Taylor Byrne, and that gives evidence about when Tavistock discovered the Titan NPS, and it was after these emails. It's not in the bundles because it's not in the grounds of appeal, but certainly we could provide that to the court, that on oath she, having taken instructions from the client, gave evidence to the court, to the judge, of the date when they discovered it. So if that's felt to be relevant, I would ask that that's put before the court.
I don't think we need that, thank you.
And then a lot of these emails simply talk about this information being available to Titan and or Tavistock. And again, in my submission, again, this will be a matter for trial, and no doubt Stephen McGregor can be cross-examined about what he made of these. But for example, page 290, can we onboard it and make it available for Titan and Tavistock? Obviously, Titan are doing a lot of work of analysing and looking at these investments. And again, Tavistock's position would be they didn't realise what was going on. And when they did, they immediately wrote and raised it in the letter of claim that you've seen. And then
Mr. Purvis explained what he said onboarding meant. That's to say that it's making the investment available to invest in, rather than actually making an investment decision to invest in that. Do you disagree with any of that?
Well, I do disagree in this sense. Onboarding is a very important process. It's the preliminary to then having it as part of the strategy. So the reason that you're onboarding something is you're likely to use it. And obviously, a competitor wouldn't know what products another competitor was onboarding unless they were party to these sorts of communications. So precisely, if we asked Titan tomorrow, could you tell us what investments you're onboarding? I'm sure we would be told, no, you can't know that. That's confidential to us. You're not entitled to know what we propose to onboard. It gives an insight, doesn't it, into what is coming. And when we look at Mr. Raven's witness statement, we will see that he sets out that timing is everything here, because you've got access to someone's internal thinking before it is publicly made available. Can I just show you at 285? Because these aren't all the emails that we will rely on either. But 285 is an example of one that we say is ambiguous in wording. It says, can you confirm has this been ring-fenced to ours/Tavistock's accounts? Again, that wasn't something that would be understood or inevitably understood as meaning that Titan has its own NPS and is developing it. And then again at 277 we see Titan/Tavistock being used as the wording. We also see Titan taking advantage of some of the deals that that Tavistock had already negotiated. Sorry, so forgive me. Yeah, so if you can look at 269, we see there an email from James Peel to Jack. Please could you confirm to Platform 1 that initial investment amounts can be waived for Titan and Tavistock for this fund. So Tavistock obviously had a deal whereby they wouldn't have to pay the initial investment amounts, and then we can see that those are asking to be waived. Now, these investment emails...
How can you tell that from that document, that it was that way round? How can you tell that there was already a deal that favoured Tavistock and then Titan sort of piggybacked on that, just from looking at that document?
Because they're emailing, they know that they're emailing for Tavistock. Obviously, now that we read it, it says can be waived for Titan and Tavistock for this fund. At the time, that would have been understood as both of them. But obviously, they were doing it on behalf of Tavistock.
Well, they might be doing it on their own behalf as well.
But the point is they can't be mixing up the two. They've been asked to...
Well, they're two separate. They're onboarding for both Titan and Tavistock, and they're saying, can you agree that the fees are waived? Just on the face of the document.
Well, in my submission, when you read it against the OMA, that doesn't make any sense, because they are doing this on behalf of Tavistock. They are being asked to promote, and only to promote, this for Tavistock. So those are the example emails which were attached, but they're only an example, and they're also there to show that now, and I think this is now admitted by Titan, that Titan were doing this for their own benefit at the same time. That is not something that was apparent to my clients at the time, and it is something that we say was not permissible under the OMA. Can I take you to Mr. Raven's witness statement, just where he explains and reiterates some of this? There was one other passage that I should just take you to. I think you have the point already before we leave the pleadings, but then that is .386.
Sorry, where am I looking?
386, paragraph 18E of the reply, in bundle 1, the core bundle.
Yes.
So 18E1 says the relevance of Titan AM identifying the investments is denied. Titan AM was undertaking work on behalf of Tavistock AM pursuant to the terms of the OMA, and Titan owed a duty of confidence to Tavistock in respect of all information concerning such investments. So that is where we set out in response to what's pleaded against us, to say, well, it doesn't matter whether you're wearing, or you can't say now that you're acting as Titan and not Tavistock because of the provisions of the OMA, because you were doing this work for us. So for these purposes, you are wearing a Tavistock hat, because that was the very work that they were being paid to do under the OMA, and I won't go over those provisions again, but that was the information concerning those investments which was protected both under the wording of the OMA and under the equitable duty of confidence. So the fact...
But if we're looking to see whether the amended pleading, which was before the judge, has a real prospect of success or shows a coherent case, whatever the test is, don't we have to confine ourselves to that pleading? Why do we look at something that comes rather later?
Well, in my submission, this just makes clear what's already clear under the existing pleading, because it's simply a matter of legal argument that what Titan is doing in terms of making these recommendations, they were actually doing under the OMA for Tavistock, so it must be treated legally as Tavistock's information, and even if I'm wrong about that, it would still be covered under 5.1, because that applies to any information created pursuant to the OMA.
Well, it doesn't, does it? It says in terms that it relates to information disclosed by one party to another.
Well, my lord, I don't agree with that, and I wouldn't accept that, because it says each party shall keep the other party's confidential information confidential and shall not, quote, use any confidential information for any purpose other than complying with its obligations under the agreement.
But that depends on the definition of confidential information, because it's a capitalised term.
Yes, but that goes back to my point that even if this was within that definition, information disclosed by Titan rather than by Tavistock, it would still fall within the terms of 5.1.1. Because it would still be, it doesn't have to just be information.
It doesn't seem to make an awful lot of commercial sense, that idea, because that means that a party who has some secret or other, which is disclosed under the agreement to Tavistock, then can't unilaterally decide to waive the confidence in that. And that would be a very surprising conclusion.
But it does make commercial sense in the context of this agreement, because this agreement was under which effectively this work that Titan was carrying out, the whole point of it being paid to carry it out was to promote the Tavistock MPS.
And as a result of that, you say, as a result of the structure of the OMA, that information produced by Titan when working in that capacity
Correct.
is in effect information with a Tavistock brand on it, which
Correct.
is then used by Titan wearing a solely Titan hat.
Yes, that's correct. So this is it's not uncommercial, my lord, because Titan can take someone else who's not working on Tavistock. They could take another investment person and they could say, please go off and do whatever work, whatever analysis you'd like to do using our confidential information, using everything that's publicly available, and create a Titan MPS. Of course, they could do that. That's why this isn't uncommercial in any way. But what would be inherently inequitable and unfair and contrary to the OMA would be to allow Titan to take the work product that it had produced for Tavistock and use that for its own benefit. That would need very clear wording in the OMA, and that isn't there. In fact, the opposite is there. So 5.1 says that if you create information, so my lady is right. 5.1.1 says that you can only use that for complying with your obligations under the agreement. So your work product that's created, that is confidential, it's not publicly available, can only be used for the Tavistock MPS. Can I then take you to Mr. Raven's witness.
Are you coming back to the second part of 153U?
I can. E.
Oh, sorry, I thought you were taking us to Mr. Ravens.
I was, but I think
Oh.
you wanted to come back to...
I'm sorry, I thought we were going there and
Sorry.
coming back.
Yeah, I did too. But never mind. If we're on 153U2 on page 248,
Yes.
you say that the inference of use is
Yes.
to be made as a result of similarities in the fact sheets. That's essentially the copyright point,
Yes.
as I understand it.
Yes.
And the underlying investments described in those fact sheets, examples of which are set out in Annex 8.
Yes.
But we were taken to the fact sheets and they show the top 5 investments, but they largely don't correspond. So why do they give rise to any inference at all?
So can I take to 323, which is Annex 8 itself, which you weren't taken to?
We
I
were.
think we were.
Oh, apologies, sorry. I thought you took it to the underline. But the page of this that's quoted in the skeleton, and I should say, I don't think this was a point taken by the judge below, in front of the judge below. But if you look at 324, the bit that's extracted out is one part of 3 parts of this. And if you look down at 323, the active fact sheet, you will see that there are more in common. So PIMCO is there. We have some Royal London. We have some Vanguard. So there's more similarity there. And then if you go over to 324, if you look at the passive fact sheet, there's only one that's different. So you have the HSBC American Fund Index is in both. The Vanguard is in both, global short term. And then the iShares are in both. So the only one that seems to be separate there is the iShares 100 UK Equity Index.
Is that different from the fourth one on the right-hand column, which has a UK in it, but otherwise looks,
Yes.
that is different.
That's slightly different. Well, the iShares North America are the iShares US Equity, so they're the same. So I think the new one is the iShares 100 UK Equity Index. So one can't start looking at that in isolation, and what you're being told isn't a fair representation of what's actually set out in the entirety of Annex 8. But the second and potentially even more important point is if you look at the overview at the top, it says this annex provides examples to demonstrate the similarities for the relevant Titan NPS profiles when compared to those for equivalent NPS profiles based on the information which is presently available to the defendants. The defendants reserve the right to supplement this annex and amend pending disclosure. And if you go back to the letter of claim, you will recall that we set out there what we needed and why we needed it to be able to plead more detail as to the similarities of it. We both don't have a wide enough range of fact sheets to work from, and we need the underlying information that goes into these fact sheets. On the face of it, you will recall we set out those 4 things that are strikingly similar between the 2 MPSs. Just for your note, that's pages 6 and 7. The risk profiles, the benchmark, and then obviously access to funds and rebalancing. But then we also explained in detail what we needed to be able to provide that.
I thought the point that Mr. Purvis made that you may want to deal with about Annex 8 was that I think this was his point, but I may have misunderstood it, was that the first two, where it looks as though there's more overlap, on Mr. Raven's evidence, could easily have been taken from the Acumen funds. I thought that was his point, and therefore it was the third one that mattered, but I don't know whether you want to make a submission about that.
Well, my submission would be this is not the way to deal with an amendment application. We haven't had proper disclosure. We set out what we needed. That was a very specific category of information to plead. What we've tried to do is take the fact sheets and set out from them what we can see. The similarities are far greater than being suggested to you, and you would be saying on the basis of this information we have no prospect.
But I think his answer to that, and this is why I'm asking whether you want to say more about it, was that, as I understand his point, the first two, Mr. Raven has accepted, could just be taken from the Acumen funds, which remained with C2, I think.
Yes, but that's a huge area. That's a huge area. I mean, the copying claim has a lot of this in it, where they say, well, we've copied it from the Acumen fact sheets and we were allowed to do that. That's an issue for trial. I don't think that is accepted by anyone. It's a huge area of dispute. But the second point is you would be preventing us from being able to plead out similarities or look at how this had been produced by not even giving us the opportunity to have the very limited category of information that we requested in the pre-action letter. If we'd had that information and we still were coming before you, then one might start getting to the realms of having a discussion. But it would be fundamentally unfair when we have done what we can with the information that's publicly available for a defendant who on the face of it seems to be producing very similar fact sheets such that they get over the threshold for copying that's going to be dealt with at trial, to then say, well, you can't see any of this information and we will have your claim dismissed without having that right to that disclosure. We have explained in detail why we wanted that disclosure. But secondly, it doesn't even make their point because there is much more similarity. It doesn't have to be identical, but we have set out there the similarity between the funds.
Well, I'm only making a narrow point here, which is I won't repeat it, but it's only the last one he says that is relevant because Mr. Raven has accepted that the first two may well just be taken by copying the Acumen funds.
Well, let's look at what Mr. Raven says maybe then. If we can look, please, at page 155 of the supplemental bundle. He gives evidence to the court on oath that in paragraph 15, it is right that he says, although some parts could be an MPS recollection.
I don't think it is on oath, actually.
Pardon?
I don't think it is on oath, actually.
No.
It may have just been counsel's rhetorical flourish, but it's wrong.
Okay, apologies. I was referring to the fact he signed a statement of truth. He has signed a statement of truth at page 159.
Yes.
But I do go back to the fact that because this is an amendment application, we don't see anything from Titan equivalent from any of the clients saying we didn't copy this, we created it. He says, verified by a statement of truth, he doesn't believe that the other investment, they could be a replication of the I therefore believe they could only be a replication of an equivalent part of Tavistock's MPS. Now, obviously, the reasons for that could be explained if we saw the underlying investment strategies and disclosure. The whole point is that the fact sheets don't give that information, and therefore we need access to their confidential information in order to be able to set that out in more detail.
Did you manage to find out the answer to the earlier question about whether there is a denial of copying the portfolios?
Yeah, we don't believe there is. Obviously, if I'm wrong on that, then we can.
No, that's helpful. Thank you.
But if we go back to 153, we see Mr. Raven is someone at paragraph 6 who's been directly involved in the management of the Tavistock MPS since 2014. And then if we go over the page to 154, the point, and you've already been taken to 11 and 12, I'm not going to go through that, but we can see, for example, halfway down, paragraph 11, we see there that Titan will be outlining the investment case for any potential change to the Tavistock MPS, including the addition of new funds. And then what would happen is Tavistock would then input into it. So the point of this is that Titan's recommendations don't stand in isolation. What they do is they work with Tavistock and Tavistock's team with all of its experience, including Ben Raven, who would then come back and say, well, either we agree or we don't agree, and let's invest in this. But then obviously Titan would know what Tavistock team, with the benefit of their experience, wish to invest in. And that obviously is confidential information. That decision-making process is confidential and is based on experience of the Tavistock team.
And so you say that is, for the purposes of the definition of confidential information and clause 5.1, that's going in what might be said to be the right direction,
yes,
in the sense of Tavistock branding being information available to Titan wearing Titan hat.
Yes, correct. So you don't have some sort of Titan recommendation in isolation. It's a process whereby the people who actually make the decision with the benefit of the experience of the Tavistock team. But it's an iterative process. There's recommendations made to the board, there are investment cases, those are discussed, and then they're implemented. Then if we look at page 155, he also dealt with whether or not the Titan MPS was ever launched. I'm not going to go into that, but I simply refer to it to show you this was a very contentious issue that was backed up with what we would say was evidence to show that it had been launched. And then if we go on to page 157, dispute 4, was the work of the investment team confidential? And he takes issue with Mr. Gailani's statement that the work performed by the investment team, so that's the Titan investment team, including as shown by the investment emails, was self-evidently not confidential. I disagree. 25, I would generally expect that any discussions between investment professionals as to the assets they intended to purchase in the future would be confidential by default. And that's we say we have a real prospect of arguing that at trial. That's not fanciful. That's common sense. That if there's these discussions going on between Titan and Tavistock, Titan cannot use the benefit of them. And then he sets out at 26 the investment. If a competitor obtained knowledge of the assets that Tavistock intended to invest in, they would gain the commercial benefit of Tavistock's investment knowledge and analysis without paying for it. This is particularly true if such a competitor obtained access in real time. Access to comprehensive historic records may also be valuable, but the value would be less. And then he gives an example. If a successful fund or portfolio makes a profitable investment, this is reflected in the fact sheet, which is published later on. Other competitors may copy and hope to benefit from the successful fund's expertise. However, by the time that the fact sheet showing the profitable investment is made public, the value of the relevant investments will have changed. A fund which mimics other funds' investments using public fact sheets will often be behind the curve, will lose out on some of the profit made by the original fund because it identified the opportunity earlier than others. If a rival fund or portfolio service has access to investment decisions in real time, then it does not have that disadvantage and can copy the investment strategy much more successfully, thereby positioning itself as a rival. For this reason, investment research and analysis is highly confidential and a significantly valuable asset for a firm such as Tavistock. And then he says, 28, for these reasons, the work of the investment team was generally confidential at the time it was conducted. So that's putting more flesh on the bones and trying to explain the pleading, which I've shown you to set out. And I say all of that should be uncontroversial and certainly should be accepted by this court as it was accepted properly by the judge.
That the profitable investment will only be reflected in the fact sheet, won't it? If the profit comes from one of the top 5 funds. If the profit comes because one of the others has been extremely successful, that won't be revealed unless it's increased in value so much as to take it into the top 5. Isn't that right? There's a limit to what you get from the fact sheets.
Well, I'm not sure that's right, because the point of the fact sheets is then the investors invest in the MPS as a whole, not in these individual funds.
Yes.
But the way it works and it manages itself together. I mean, obviously there's an issue of fact.
But the competitor, looking at a fact sheet and comparing it with the last month's fact sheet, may see it's done tremendously well that month, but unless there's been a change in the top 5 holdings over that month, you won't know anything about why it's done well, will you? I might be missing something. Probably am.
Well, I think there are 2 answers to that. One, obviously, Titan had access to a far greater range of information than just the fact sheet. So it knew what was being done and why it was being done.
No, but I'm just looking at what Mr. Raven says about what a competitor can do, and I'm just be behind the curve, but you may not. You may not be on the curve at all.
No, I may not be. But I think that in some ways you're right in this sense, that there is always going to be a body of undisclosed confidential information behind the fact sheets, that it would be even more valuable for a competitor to know. I think the simple point he's making is knowing ahead of time what funds are going to be invested in does give you an advantage, because you know what your competitors are looking at, so you can look at them. I think that point is being made, but it could also be built upon to know once you have access to all of the information, like the investment strategy. And then 158 is obviously where he set out information required for the creation or management of an MPS. And this was really, I suppose, to deal with the point you made to me earlier of, well, what is an MPS? From an external perspective, an MPS is a single defined product. In fact, it's comprised of a collection of documents, agreements, and investment philosophies which are built up over time into a set of strategies and related investments which are appealing. And then he explains a bit more. A party who wished to set up their own MPS would need to invest a substantial amount of time, resources, and expertise. They would need to identify and negotiate agreements with suitable fund managers, identify and investigate a range of assets suitable, benchmark them, determine appropriate asset allocation, establish mechanisms to monitor and update them over time, and then obviously you need the fact sheets and the various information. And then he says 31, a relatively small proportion of the information relating to an MPS is initially public, and then he sets out information relating to live or future investments strictly confidential. And then we also publish fact sheets which specify some limited detail. For example, the top 5 investment holdings. And then, in fact, he makes your point that you shouldn't, it's not generally advisable to copy a party's historic investment decisions, but access to their real-time strategy decisions could be very valuable. So that's really illustrating the point of what there is confidential and valuable information. And then 32, Tavistock alleges that Titan misused confidential information in order to create the Titan MPS. I understand that Titan has criticised the degree to which Tavistock has provided a list of the exact confidential information that was misused. Titan was in an advantaged position in respect of the Tavistock MPS with access to its core workings, including live information regarding future investments and strategy. And here he makes the point, prior to disclosure, I am not able to say for sure what information Titan copied or misused. However, in my experience, the information which would have been helpful is likely to have included the structure of the MPS, factors such as the way in which risk is categorised and assigned. The reason for that is the fact sheets will not show everything. Information from the Investment Committee and the Abacus Investment and Oversight Committee regarding matters such as investment strategy and appropriate assets to onboard, and then information received as to rebalancing of holdings within each portfolio so that proportion held is returned to the appropriate level of risk. And we've seen in relation to the rebalancing, I took you to one of the investment emails, where we now see that Titan in real time was rebalancing its own portfolio apparently, or appears to have been, at the same time as it knew that that's what Tavistock was doing. There's no way that someone in the market would have access to that sort of information without being privy to what Tavistock was doing. So it's not just the onboarding, it's also the rebalancing information which enables that to happen.
Ms. Day, how are we doing? Because I'm becoming quite concerned about the time.
Yes.
Are you taking us back to the pleading? Where do we go now?
Yes, I'm aware of time. I just want to look very briefly at what Mr. Gailani said in response, and then I will go back to the pleading. So if you go forward to page 194 of the bundle, please. And in fact, if you start at 193, and he says the MPS amendments, and then he deals with the allegation of hearsay evidence. He then says 29, the Titan parties are relying on information provided by David Chandler and Sekar Indran, blah, blah, blah. And then if we look forward at 194, page 194, we see that there are some comments on Mr. Raven's witness statement. But what's interesting is that he doesn't take issue with many of the points that I've taken you through. So he sets out at 32 that the Titan parties accept the final investment decisions were made by Tavistock. They then say they were based on and reliant upon the Titan investment team's financial analysis. Now, that's obviously an issue of fact for trial, the extent to what happened. But what's interesting is he then goes on to set out all the things that Titan were involved in, which in my submission is further examples of confidential information that Titan was party to. So paragraph 33, the investment committee meetings, those took place between Titan and the Tavistock Investment Committee on a monthly basis. And you'll see that slides were prepared for that, and then there were discussions. And if you look down, you'll see he says, as is made clear on the title slide, this was, quotes, prepared by Titan AM for Tavistock. So once you start looking at the underlying documents here, you will see that what was being presented at the time by Titan was not, well, here's some information which we might use, but you might use too. This was being prepared by Titan for Tavistock. And then we have the attendees.
That was for the meetings with the Tavistock Investment Committee.
That's correct, yes.
So it's not a particularly surprising thing to put on it.
No, but to the extent, for example, that information is then used to build the Titan MPS, we would say that's clearly using confidential information. And then we see, if we go forward, at 196, the investment team would carry out policy quantitative analysis to ensure that an appropriate investment strategy was maintained. We know investment strategies are agreed to be confidential by the parties. This was then communicated, it was used and implemented by the Tavistock Committee to give effect to the MPS rebalances, and then those rebalances are used, as we've seen, by Titan. And then he simply deals at 197 with it not being launched. There's nothing else that he comes back on in Mr. Raven's statement to dispute. So can I just come back and have one final go on the pleading? Just to deal with the point that the court has raised with me. If we go back to 153N, which is the pleading of the confidential information. And if I can just try and have one more go at this in conclusion. Our claim does allege in 153N that the portfolios were confidential. And a portfolio is ultimately a bundle of assets reflecting investment decisions, investment strategies, risk analysis, etc. It's all confidential except to the extent that a high-level summary goes into the fact sheets. And the nature of the confidential information inherent in a portfolio is expressly set out in the sub-paragraphs of 41 that we looked at. It's page 191 to 192, which are cross-referenced in 153E. So we say this isn't a point, and this appeal really isn't about specificity of the pleading or its coherence. It's turned into a question of whether the contractual and equitable duties go that far. That's what we've mainly been discussing. And I would reiterate to the court that that is a point for trial, particularly on the equitable duty of confidence, but also on the contractual duty, because we don't have all the evidence of factual matrix, etc. The High Court wasn't asked to rule on equitable duty or on the construction of the OMA, Clause 5, on a summary basis, and neither should this court. We have set out what our pleading is. We have done that to the best of our ability based on publicly available information. We are told we cannot have the information we requested in pre-action disclosure, which because it is confidential. One of the things that the judge offered during argument was that that further better particulars could be requested and dealt with, and that was something that wasn't attractive to the Titan parties. But certainly these criticisms are misplaced without at least giving us the opportunity to see the pre-action disclosure that we requested. And that would enable us to provide more particulars. The point the judge was making about the particulars and the request that was made was simply that those had made a request about paragraph 153N. But we don't hang our hat on that point. The important point is that this claim is properly pleaded out, and we do fall, we say, within, just to finish with the law, because you were taken to Shenzhen, but just to make sure you have the relevant paragraph in that. Selgaard and Shenzhen, it's page 251, paragraph 48 of the authorities bundle. And halfway through that paragraph, you will see, and this is referred to in the judge's judgment, what amounts to sufficient particularisation must depend on circumstances of the individual case. Furthermore, a lesser degree of particularisation may be acceptable at the outset of a case than at later stages of the case. Still further, I accept that it is relevant to take into account the claimant's ability to provide further particulars and the extent to which the claimant has been hampered by obstructiveness or at least non-cooperation on the part of the defendant. And then obviously he deals with the circumstance to say Selgaard has done enough for now, although we'll undoubtedly have to give further particulars at a later stage. I've taken you through 153N. We've set out there to the best that we can what information was confidential. We've explained the basis for the contractual duty, the basis for the equitable duty. We have shown you the pre-action correspondence that the judge refers to, because that was important. We have been refused unreasonably in my submission any of that information. Even the fact sheets we've not been given. We haven't been shown the investment strategies. We haven't been shown anything that it's now said to you cannot be confidential. And it would be, in these circumstances, fundamentally wrong to interfere with the exercise of discretion that the judge carried out in terms of the decision that he made, not just on this point, but on a number of points in relation to this case. And you should dismiss the appeal.
I know you say you haven't been given the fact sheets, but I thought they were publicly available.
No, they're not. So what we haven't got all of them. So we have what we could get hold of before they were taken down, but there are obviously more that we don't have.
But you're going to get them on disclosure because of the copyright claim.
We will get them on disclosure.
Yeah, when are you going to get them? Do you know?
Pardon?
When?
Well, that's a difficult question because there was a refusal by Titan to give any disclosure in relation to MPS pending this appeal.
But I thought you said it's now agreed that you're going to get them.
It's agreed in relation to the copyright, yes. It's not agreed in relation to some of the MPS have been agreed, but we've got more hearings in the High Court.
Right, but so you don't know yet when you're going to get the documents which have been agreed?
24th of July is the date which they have to be provided by in the order.
So on the 25th of July, you'll be able to compare them with yours, and that will tell you whether there is wholesale correspondence within the top 5 holdings or not.
Well, what we would need, my lord, is what you see at page 10 of the supplemental bundle. And I would repeat my request for those to be provided as soon as possible. Full details of the investment histories from 31st of January 23 to 1st of October 24, including all details of investments and rebalancing. And then copies of all fact sheets from 31st of January 23 to 1st of October 2024. We need both of those. That's why we identified them as the key documents. That category of information would not have been difficult or onerous to provide. We reasonably requested it, and it's been refused on the basis it's confidential. And yet we are told we cannot proceed with this claim. It would be fundamentally unjust for this court to say in those circumstances we get struck out for a lack of particularisation. If that had been provided, and if we had not produced what it said we should produce, then one could see why we were here. But it would be fundamentally wrong to disturb the judge's judgment in these circumstances, and therefore I would ask you to dismiss the appeal.
Thank you. Mr. Purvis?
My lady, my lords, I was going to concentrate on the basis of the pleaded case, which is now being advanced. And as I perceive it, my learned friend really has 2 points.
I'm sorry, I'm funny.
I'm sorry, I was muttering rather.
And I was moving
Orating.
things about, and I apologise too.
I do apologise. My learned friend, I think, really has 2 points at a high level. One is this allegation, which I shall submit is entirely unpleaded in the statement of case in terms of the counterclaim, which is the subject of this appeal, which is the allegation that the claim for breach of confidence includes information which was created by Titan in the course or during the existence of the OMA and provided to Tavistock. We can see why my learned friend likes that idea, because everyone's agreed that recommendations about specific investments were provided and that this has the character, if one imagines sitting in on an internal committee meeting, has the character of something one would consider may be protected by business confidence. Of course, there's then an enormous issue as to on what basis my learned friend would claim any proprietary right, as it were, in that information, or would bring it within the terms of the OMA. And I think your lordships, my lady, have that point, because there's already been a long discussion about the proper construction of the OMA. But from my point of view, the simple point is that this plainly is not pleaded at all. The pleading is explicitly limited to information provided by and created by Tavistock itself. And for that purpose, I'm content to rely on 153E, which my learned friend contended was a general introductory paragraph introducing the causes of action, although one might say that's a slightly odd characterisation, given that it's the only paragraph that involves any specifics. But what it does say is that Tavistock AM communicated information necessary to implement the Tavistock MPS to Titan. So that's flowing from Tavistock to Titan. 153M, which is the first plea under the heading breach of confidence. In creating the Titan MPS, Titan used or authorised the use of confidential information and other trade secrets created and owned by Tavistock AM.
Sorry, what paragraph was that?
I'm sorry, 153M on page 246. And then at 247, at 153Q, each part of the Tavistock MPS information was imparted to Titan AM in circumstances importing an obligation of confidence, etc. And then it's in those premises, as you see in 153R, Titan owed a contractual and or equitable obligation of confidence to Tavistock. And in those premises, the Tavistock MPS comprised a trade secret for the purpose of the regulation in 153S and 153T, Tavistock was the trade secret holder. We submit that could not be clearer, and it is not open on the face of this pleading from a learned friend to advance a case that she has done, which she says derives from the reply, and to, as it were, piggyback from a reply into a completely new, unparticularized, unexplained cause of action. It has huge difficulties anyway, even if Milena Friend had put forward a proposed amendment. The suggestion that a party whose expertise has been is being contracted for the use of and comes along and makes advice about what investments would make sense for a particular client is somehow prohibited from using the skill and knowledge that had given it that insight in the first place to make investments itself or to advise other clients is, we submit, quite untenable as a matter of commercial reality. And the simple example of the recommendation in a particular case of the Vanguard US equity fund as something that might be a good investment this year, and the idea that once you've done that, you are unable yourself ever to invest in the Vanguard US equity fund is, we would submit, extraordinarily difficult one that would require very specific terms in an agreement. One would ask, well, when does this obligation cease? I mean, is it a limited obligation? You can't use it for a month, or you can't use it for 6 months, or you can never invest in it. We submit.
Well, that's an extreme example, isn't it? That's not really the case against you. The case against you is that there has been wholesale duplication in your model portfolios of what is in the Tavistock model portfolios. And I know you say that doesn't appear from the fact sheet comparison that we've got.
Yes.
But that's a bit different from simply can't invest in Vanguard.
Well,
Are you saying you're allowed to create essentially a duplicate of the Tavistock portfolios for your own purposes?
Well, if that was, I'm sorry, I'm trying to distinguish two potential causes of action here. The one that I perceive my own friend is arguing for, which is the idea that that information which has been provided by, as a matter of recommendation, which I think is the case she's putting, has been provided by recommendation by Titan to its client for this purpose, namely certain recommendations about new funds that have arisen, the kind of things we see in the emails, and they might be worth investing in. There is no reason on earth we would submit why Titan, which have their own investment funds, not only MPSs but other things as well, can't use that insight and that information themselves for their own benefit. If there's another case, so far as my learned friend is concerned, which is a kind of implied term that you can't compete with an MPS using that kind of insight, and that's the sort of inwardness of the OMA, that could be a case that might be advanced by way of pleading. We would not accept that, but it's not pleaded, and therefore.
Well, I thought you were on the you dealt with the pleading point, and then
Yes,
you were saying, well, anyway, there's huge difficulties on the merits. And
Yes.
and you gave your Vanguard example, but I was trying to bring it back to something closer to what is actually alleged.
Maybe ships passing in the night. I hadn't. Yes. I'm not saying it wouldn't be necessarily possible to try and create a pleading based on the OMA, implied terms thereof, which one could then look at and say, well, is that arguable? I'm somewhat in difficulties because I haven't seen such a plea, and therefore it's hard to address the nature of the allegation. But your lordship says if it was very specific and limited, perhaps, who knows? But the problem is none of this claim has been ever put in the pleading in this limited way, or indeed at all by reference to information flowing in the Titan to Tavistock direction, and that's the key point here.
Well, I just tried to think ahead to what's going to happen, or what might happen. I mean, if we dismiss the appeal, well, that's one thing. But if we were to allow the appeal, and you then disclose on the 24th of July all the fact sheets, and those fact sheets show massive duplication of the top 5 holdings, let's assume, so that the inferences which at the moment Tavistock are doing their best to rely on, and you say look a bit shaky, suddenly have a rather firmer foundation, what then?
Well, if my learned friend wants to put forward have another go at a breach of confidence plea that says, here is our confidential information, it is that in April 2024, here is a set of investments. And we say you use that complete set of investments on that day and duplicated our MPS. That is an allegation which would be comprehensible and could be addressed. That isn't the way the case is pleaded, of course, now. But one's sort of looking forward to a very, very different case. And what's pleaded now is something like, well, there's an unlimited raft of confidential information that I'm not going to define. And we say you must have used some of it to do something. And also, we're only relying on information that we imparted to you. And when my learned friend is pressed on it, she talks about strategies. But one would expect to see in a pleading, if one was going to rely on an investment strategy, a schedule that set out the strategy. That's the way it's normally done. Defined it in a particular way so that one could actually address the case as to whether A, that was confidential or trivial or public, and B, whether or not that had been followed. Similarly, internal risk profiles. I mean, there was an exchange between the bench and my learned friend about whether those were any different from the standard risk profiles used in the market. Again, we know nothing of this from the pleading. There are no specifics at all. Is it being said against us that our risk profile of 3 is in some way copied from Tavistock's risk profile of 3? I mean, that raises, if that's going to be alleged, one would need to know from Tavistock what they say their risk profile is, in order that one can work out whether that's something that's confidential. And so far as Titan are concerned, of course, the point that underlies a lot of this is, of course, it's the Titan investment team. They haven't left Tavistock. They always worked for C2. The shareholding in C2 has passed to a different company, but the company still trades, and these are the same people that have always been working and have, no doubt, favourite ideas about what risk profiles make sense and so on and so forth. So the distinction that will then have to be drawn between the ordinary skill and knowledge of the individual members of the investment team at Titan and some proprietary confidential information is one that would have to be gone into. But until one knows what the case is that's being put, then it is impossible to plead back to. When my learned friend plucks parts from the evidence, she plucks parts from the letter before action, and says, oh, well, it's this kind of thing, it's this kind of thing. But the purpose of the pleading is to crystallise the claim that's being made. And if she's going to say, well, we're relying on our investment strategies, it's fair for the court to say, well, you must know, therefore, what your investment strategies are, and you must be able to define them in order for the claim to be properly brought. And that's what we just don't have in this case.
Well, I follow that. At the moment, I'm simply thinking about the fact sheets and what inferences might or might not be capable of being drawn from them.
Yes.
And since there cannot be more than a few hundred documents, maybe 1,000, all of which presumably be in much the same place, I mean, couldn't they be produced rather sooner than the 24th of July?
Well, in principle, I don't have that information. Yeah. Yeah. Well, Your Lordship asked me specifically about the fact sheets. Of course, what's been going on in terms of the disclosure negotiations is that the other side are claiming far broader.
I'm sure they're in a vast amount of material, but at the moment they've pleaded an inference from a fact sheet, and you have made the point. Well, once you disregard the two Acumen ones, the one that's left doesn't seem to correspond very much. So one might have thought, one might have thought that your side would have done some analysis already to see whether you could make that point more generally. Look, here's our fact sheets for these months. For these funds, they are nothing like the Tavistock ones.
Yes.
I don't know if you've done that exercise or not, and you don't have to tell me because it's privileged, but I might have thought you would have done.
Yes.
And then one would see that either there is absolutely nothing in this inference because there's no correspondence at all, or alternatively, maybe there is something.
Well, if the claim if the claim was to be limited to the balance of investments in a fund at any particular time, as shown in the fact sheets, then yes, one could easily just compare the fact sheets, and we wouldn't be here, I'm sure, if that was the scope of the claim that was being advanced against us. Then that's something that could easily be looked at. I mean, the reason we're here is the vastly broad and unspecific nature of the claim that's pleaded. So I don't doubt what Your Lordship says. Assuming that we still have access to all these fact sheets, it wouldn't be in principle difficult to find the fact sheets. I'm sure that's right.
All right, well, that's probably as far as I can take.
But Your Lordship's got my primary submission on the breadth of the claim and the difficulty of the pleading. I'm trying to skip through my notes on my learned friend's submission.
I think you said that you only perceived today as having 2 points at a high level. You told us what one of them was. I'm not sure you've told us what the other one is.
Well, I think the other one was that, so far as the rest of the case is concerned, she should be excused the requirement of properly pleading the nature of the confidential information with precision, because she and her clients can't be expected to know what has been taken. And we submit that is very much putting the cart before the horse. Unless one can properly define a claim, it is not possible for the defendant properly to plead back to it. And it's not that my learned friend doesn't know what kind of confidential information her clients might be able to claim, because discussions have already taken place in this court about investment strategies, about risk profiles, just to take those two examples I gave earlier. It's simply not the case that the confidential information can't be pleaded with greater particularity. All those things could be properly defined and identified, just as one saw in Shenzhen, where the claimant had gone to a lot of trouble to identify specifics of what would be said to be the confidential information in order to limit the nature of the claim that's being brought. It doesn't help, we submit, to pluck out bits of the letter before action, pluck out odd bits of the evidence and say, well, it's that kind of thing that the case is about. The appropriate way to deal with confidential information is to set it out and plead it, not to expect the defendant to root out a case from the evidence or other documents which they might be able to find. So really we say there isn't an excuse in this case for the absence of a proper claim. And I've taken your lordships through the incredible breadth of what's alleged. And the fact that at the end of the day, the claimants have simply refused to try and put the case in the proper form in which one would expect to find a breach of confidence claim pleaded and alleged. I'm conscious of the time going. I think you've probably had enough submissions from both sides on this issue.
As long as you said what you want to say.
Thank you.
Thank you very much. And thank you to everyone and to those behind who have no doubt done a huge amount of work but have not spoken today. We will reserve our judgment, you'll be glad to hear. And you'll be very aware of the procedure in this court, that we will circulate drafts of our judgments for the correction of grammatical and typographical issues only, and that we take the embargo on that draft extremely seriously, so we warn you about that. And as you will also very well know, we hope that you are able to agree consequential matters, and if not, please submit very short written submissions as to your differences, and we will resolve those matters on paper. Thank you very much indeed.
Thank you.
All rise if able.